By the way, did I tell you all? We're on a new schedule. Every day, new video, 6 p.m., no exceptions. Well, hello everybody, and welcome back to your favorite show on the internet, Raw Law Unfiltered, with your favorite host of the DUI Guy Plus. Today we're going to be covering something very different from the last couple of videos that we have been doing, and some of you who have been joining our lives over the past few weeks know that there is a case happening in Massachusetts on April 16th, 2024. Commonwealth of Massachusetts versus Karen Read is the case. The jury trial starts on April 16th, 2024, and it will go on for presumably somewhere between 5 and 7 weeks in length. Well, the thing about the Karen Read case is that there is a separate matter parallel to the murder itself that is happening in Massachusetts courtroom. What do I mean? Well, Commonwealth of Massachusetts, single justice of the appeals court. The protesters in the case hired an attorney. His name is Mark Randazza. And Mark has been representing them. He's the one who filed the motion in opposition to intervene in the Karen Read case, opposing the motion by the Commonwealth for the 500-foot rule, okay? Him, along with the ACLU, American Civil Liberties Union of Massachusetts, ACLUM, both filed a motion. Now, Mark Randazza filed his motion to intervene in the case, whereas the ACLUM filed a amicus curiae brief, or also known as an amicus brief. Amicus is literally Latin for friend of the court, okay? That's what amicus stands for. And an amicus brief means a friend of the court brief, or a brief of a friend of the court. What did they allege? They alleged to Judge Beverly, or Auntie Bev, as a lot of us like to call her, because, I don't know, the woman does not commend respect, in my opinion. I'm sorry. I said it. Auntie Bev, as she has come to be known, decides to split the baby, as a lot of judges do when, no offense to her, or maybe all offense intended, doesn't know what the heck she's doing. So she splits the baby, she gives the Commonwealth what they want, which is a 200-foot rule, instead of a 500. What am I talking about? The Commonwealth filed a motion on or about March 25th, and the motion was finally heard on April the 4th, of 2024, to institute a 500-foot rule to not allow people to demonstrate or protest or wear any insignia supporting Karen Read, supporting the prosecution, supporting the government, supporting John O'Keefe. Nothing. No clothing, no signage, no insignia shall be permitted. I mean, can you think of a greater First Amendment violation than to say, you know what, we're going to take away your First Amendment right to protest? Are you kidding me? Oh, I was furious when I saw that. And I said, okay, you know, Auntie Bev still has a week until her ruling. Let's see what happens. And of course, on April 4th of 2024, 4/4/24, Auntie Bev rules. And she rules, I deny your 500-foot motion. Hooray! Wait, don't be so quick to celebrate. What? What do you mean, DUI guy? What I mean is, she allowed a 200-foot buffer, not just around the courthouse, but surrounding structures and including the parking lot of the courthouse. Because naturally, jurors are going to be going through the parking lot. Talk about a greater First Amendment violation, right, folks? I mean, it doesn't get much more disgusting than that. And why is it not covered in the media? Because it's not sexy. It's not enticing. Nobody died. Nobody got kidnapped. No celebrities involved. It's really disappointing. It's really, really disappointing because this should be national news that protesters are prohibited from literally just picketing in front of the courthouse. Now, the defense did try to sneak one past this. I was watching it live, and the video is on my channel, so feel free to go check it out. If I don't forget, I will add it in the description below. The judge made this ruling on April 4th. The defense chose not to respond. They wanted Auntie Bev to hang herself. You know, you are going to create your own noose and hang yourself with it. Be our guest. This is all you, Auntie Bev, right? So she institutes the 200-foot rule, and it is now in effect. I am recording this video at the time of the recording of this video, which is April 15th in the evening hours. We are about 12 hours away from the beginning of the Karen Read murder trial. A few days ago, Mark Randazza, the one who represents the protesters, Tracy Ann Spicuzza, Lorena Jenkinson, Dana Stewart Leonard, and Paul Cristoforo have filed an appeal. An appeal from an interlocutory order of the Norfolk Superior Court, Norfolk County. A memorandum of law in support of petition for relief under the law that allows people to protest by interveners, appellants, Tracy Ann Spicuzza, and others. And they write, interveners, Tracy Ann Spicuzza, Lorena Jenkinson, Dana Stewart Leonard, and Paul Cristoforo herein petition the single justice under GLC 211 Section 3 for relief from the interlocutory orders of the Superior Court. The issue at hand. The principal purpose of the First Amendment's guarantee is to prevent prior restraints. The Norfolk County Superior Court created a prior restraint zone, prohibiting all demonstrations without defining that term in a vaguely defined area, but clearly encompassing a broad swath of traditional public forums. I couldn't agree more. It did so without considering arguments that could have helped tailor the relief when it declined to hear to those who would be directly impacted by the creation of the prior restraint zone. The Superior Court had no power to legislate such a zone. The Superior Court, and by the way, every time we hear the word Superior Court, that's Auntie Bev. The Superior Court refused to even consider narrow tailoring and made no findings to support its actions. In a case of Richmond Newspapers versus Virginia, closure of a courtroom required findings to justify its actions. Closure of a traditional public forum must require the same. And Auntie Bev failed to do it in this case. So says Randazza on behalf of the protesters. The Superior Court refused to consider less restrictive means to address the Commonwealth's ill-defined concerns, and the Superior Court declined to so much as hear these dissenting voices when, as here, a prior restraint impinges upon the right of the public to speak and forbids pure speech, not speech connected to any conduct. The presumption of unconstitutionality is virtually insurmountable. And that's in Providence Journal, a federal First Circuit case. If a court wishes to take away the right to protest, it may not do so without at least entertaining the protesters' arguments to the contrary. And this court refused to do that. If you watch the video.
So I have received something styled a citizen's motion to intervene.
There it is.
And I think criminal counsel surely knows that unlike civil, there is nothing in the mass rules of criminal procedure that supports intervention in a criminal case. But I've read the memo. I received it yesterday and I've read it. I am not going to hear from counsel. I do want to say, and quoting the appeals court, intervention is a concept foreign to criminal procedure.
The knowledge that every criminal trial is subject to contemporaneous review in the forum of public opinion is an effective restraint on possible abuse of judicial power. Without publicity, all other checks are insufficient. In comparison of publicity, all other checks are of small account. That's from In Ray Oliver, those two statements. In this case, the media, aside from one outlet, has been largely absent from performing its fourth estate functions. But demonstrators have taken up that slack. The lower court's actions, meaning Auntie Bev's actions, especially the way its order was crafted, create at least the impression to the public that it was not done for the stated reasons, but rather to insulate itself from publicity and meaningful criticism. I mean, listen to that language. He's basically saying, I see what you're doing, Auntie Bev. You're trying to put yourself in the little bubble. You're trying to lock yourself in the little box like, la 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 la, the real world doesn't exist, la 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 la. And you can't do that as a judge. You can't do that. Oh, it makes me so mad. Now, the procedural history and relevant facts. Commonwealth versus Reed has been the subject of intense public attention, as you can clearly see. I'm making a video on it again. And there have been regular peaceful demonstrations around the courthouse throughout the pretrial proceedings. Demonstrators appear to have exclusively been in support of the defendant, Karen Read. This is very important. On March 26, the Commonwealth asked for a 500-foot buffer zone around the Norfolk County Superior Courthouse during the Read trial, banning a broad range of constitutionally protected speech. The Commonwealth asked for this prior restraint zone because it claimed that the Commonwealth has a right to a fair trial, and that the Commonwealth failed it could not get a fair trial without banning the protests. On April 2nd, interveners filed a motion to intervene for the limited purpose of opposing the request to close the outside to assembly and protest. Now, the Superior Court denied the motion to intervene without a hearing, as we just saw, stating only that the motion was denied for reasons stated on the record. The Superior Court orally stated that intervention is never permitted in criminal cases, which is false. Okay, so there you have it. I stand corrected. Maybe it is. The Superior Court then established a 200-foot zone where, among other things, inter alia is Latin for among other things, quote, no individual may demonstrate in any manner, including carrying signs or placards, within 200 feet of the courthouse complex during the trial of the case, unless otherwise ordered by this court. The Superior Court, however, claimed that this was to protect the defendant's rights. What? All these people peacefully protesting, free Karen Read! We need to protect her rights. This is wrong. Free Karen Read is wrong, and it's bad for the defendant. Huh? What?
Mark Randazza.
This is clearly not the case. Defendant Read did not seek this relief. She took no position on the Commonwealth's motion. Rather, it is clear the Superior Court acted to protect the Commonwealth from protest, or to protect the court itself from embarrassment. It strains belief that the Superior Court entered an order banning demonstrations in favor of Karen Read to protect Karen Read. I mean, that just baffles the mind, doesn't it? Denial of intervention was improper. When a trial court tries to take away First Amendment rights in its very realm, the Supreme Court requires that it make specific findings justifying closure. Here, it failed to do that and failed to make findings denying the intervention. Meanwhile, when courts seek to close courtrooms where they have greater powers than they have over traditional public forums, intervention is preferred. There it is. So Randazza does have a right to intervene. Interesting. So Auntie Bev did not cite correct law? The correct procedure for a non-party to challenge a protective order is through intervention. Intervention is the most appropriate procedural mechanism to challenge closure. Where the government seeks to shut down traditional public forums in the absence of statutory authority upon which it could be based, the case law is not as rich with cases on point. Now, this may be because it has been obvious that a judge lacks authority to issue such an order. This appears to be the case of first impression, where a court seeks to extend its tentacles outside of its realm, the courthouse, and ensnares all demonstrations on property it doesn't even control, including traditional public forums and even private property. The court failed to precisely define where this First Amendment exclusionary zone is, stating that it is 200 feet from the court complex. The court seemed to mean 200 feet from the outer edge of all court buildings and parking areas, but the court's imprecision leaves citizens to guess where the zone begins and where the zone ends. As it stands, the order includes the insides and grounds of the library, churches, houses, and businesses, as well as streets and sidewalks. That's how crazy this thing is. It is a case of first impression, folks. There are cases discussing legislative authority over such cases, such as Cox versus Louisiana from 1965. But despite a good faith effort to find one, Intervenors Counsel is unable to find a single case where a court purported to command contempt authority over demonstrators outside the courthouse grounds. I mean, this is madness. However, there are analogous cases to consider. When courts seek to close their own courtrooms, like something they certainly have the authority to do under the proper conditions, third parties, usually media entities, are nearly always permitted to intervene. It is an affront to due process that a court can deprive hundreds of people of the First Amendment right without an opportunity to be heard. Non-parties may intervene where they would otherwise suffer a substantial injury to a direct and certain violation of their rights. Number 4, the Superior Court's prior restraint order should be struck down in its entirety or narrowed by this court. Courtrooms were long open to the public at the time of the founding. Thus, the First Amendment prohibits government from summarily closing courtrooms. Again, that's Richmond Newspapers versus Virginia, 1980 United States Supreme Court case. Sidewalks and streets and parks outside a courthouse are given an even greater First Amendment deference than the inside of a courtroom. For the First Amendment does not speak equivocally. There's no equivocation. It is unequivocal. It must be taken as a command of the broadest scope that explicit language read in the context of a liberty-loving society will allow. I mean, this is almost like Scalia breathing life into the First Amendment. You can almost hear him in the room. I'm talking, of course, the long since deceased Justice Antonin Scalia, for those of you who may not be familiar. And he was a very big proponent of trying to breathe life into the Constitution. He was an originalist, I believe is what they called them. An originalist. He'd like to try and, if he were George Washington, how would he like to interpret the Constitution? I believe that's what they called them. But don't quote me on that. I haven't done this stuff since law school, and it's been like 11 years. Sidewalks around courthouses are traditional public forums. Actually, it's been 13 years since I sat for con law, so there you have it. The court's prior restraint zone substantially and directly violates the First Amendment. The Superior Court did not even consider, much less correctly analyze, its obligations to narrowly tailor the zone. That the Commonwealth sought an even broader zone does not mean that the court did its narrow tailoring duty. In fact, the Commonwealth asked for 500 feet from the courthouse, but the court implemented what seemed to be a larger area of 200 feet from the courthouse complex. Even the Commonwealth, therefore, seems to have asked for a narrower tailoring than the court implemented. I mean, you can't make this stuff up, folks. Nor did the court consider, much less implement, any less restrictive means. The Superior Court simply napalmed the entire First Amendment in a vaguely defined area. To further complicate the process, the court did not even define the word demonstrate, a broad swath of constitutionally protected conduct that would have no possible effect on the purported purpose for the zone. Given the ill-defined term, citizens are left to guess what they can and cannot do. Can they march in a single column? Not if demonstrate prevents that. Can they hold a candlelight vigil? Probably not. When they were left to define demonstrate on their own, and the penalty for guessing wrong is contempt, this does not even meet rational basis review, much less strict scrutiny, which is one of the standards for First Amendment review when you want to deprive someone of their constitutional right. Temporally, when does this restriction apply? The Superior Court said it was during the trial. Is that the 6-week period during the trial? Or is it the technical interpretation of gavel to gavel? If the former, that would mean that even at midnight on Saturday there could be no demonstrations. If the latter, then what purpose does it serve? Since the jury will not be outside, but will be in the courthouse? The Superior Court's order is so unbalanced that it does not stand even slightly rational basis. Number 5. In the alternative, interveners ask, if the court does not strike down the order, it should pronounce that the order has no effect. What powers was the Superior Court entrusted with that gave her authority over the general public or over the streets, sidewalks, or public property in her First Amendment exclusionary district that she legislated? The order seems so transparently invalid that demonstrators of extraordinary firmness might simply ignore it. In relying on In Re Providence Journal, a case that was cited previously, the court said, an order entered by a court, clearly without jurisdiction over the contemners or the subject matter, is not protected by the collateral bar rule. Were this not the case, a court could wield power over parties or matters obviously not within its authority, a concept that is completely inconsistent with the notion that the judiciary may exercise only those powers entrusted to it by law. However, in that landmark case, the Providence Journal did not face being thrown in the jail cell for ignoring a patently unconstitutional order. Interveners certainly could. They should not be forced to violate the order, get locked up, and then challenge the contempt. The court should rein in the lower court. Randazza is saying, Court of Appeals, put Auntie Bev in her place. Interveners should not be left to guess whether this is the case. In conclusion, in light of the foregoing, the single justice should vacate the order of April 4th, denying interveners' motion to intervene, and either vacate the creation of a prior restraint zone or narrow it to a constitutionally permissible degree. On behalf of Tracy, Dana, Lorena, and Paul, Mark J. Randazza. Yeah, folks, it does not get crazier than this. It does not get crazier than this. I mean, I can't wait. My flight is Tuesday. I'm going to be in Massachusetts for a very small part of the trial initially because I have to come back to Kentucky for a jury trial of my own. I'm second chairing my protege's second jury trial this coming Friday, April 18th. So I'm really excited about that. I want to see how he does. It's a tough one. This one is a tough one. I mean, his first one was a tough one too, but this one is a tough one as well. But I'll be back. I'll be back in Massachusetts, but I definitely want to be there, and I will be there on Wednesday to see the shenanigans in the flesh with my press pass. I can't wait to see what is going to happen in the Karen Read case. It is a cluster of a case. There is no evidence that Karen Read hit her boyfriend with the car. There is zero evidence that she killed him. There is zero evidence that she is the culprit, and there is zero evidence that she is somehow involved. All we have are conspiracy theories, speculation, and complete conjecture with falsified records and one broken taillight with no injuries consistent with a car accident. Clearly, injuries consistent with being in a fight. I can't wait to listen to the state's experts try and bend over backwards to try and justify how Karen Read was the person driving the vehicle and killing John O'Keefe III. Hashtag free Karen Read. Hashtag justice for John O'Keefe. Folks, I thank you all for joining me. I hope you learned something today, and I will see you all in the next video tomorrow, 6 p.m. Eastern Time. By the way, did I tell you all? We're on a new schedule. Every day, new video, 6 p.m., no exceptions. Stay tuned. Bye, everybody.